You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
That piece of cardboard that you bought from someone was not a legal tag, then they'll let us know and you'll still owe that money.
I'm sorry?
The beneficiary and not the artificial person, sir.
Okay, I don't know what you mean by that. What's your name?
I'm the beneficiary, Michael, of the Blade family. I live in the domicile of the United States of America Republic, sir.
Hey, what do you have to, was it Monroe County, Michigan?
The domicile of the United States of America Republic.
All right. The court's not gonna play games. The court's gonna dismiss this complaint for lack of jurisdiction, Ms. Blade.
You attempted to sentence me to football numbers, so it just, I don't see how it was just constitutional as far as you ruling in the direction that you did on the motion, honestly, sir.
That's out of my hands. You have appealed it. You'll pursue that appeal, and we'll see where that goes. But I don't have jurisdiction over that order now because you have challenged it.
Good morning, sir. What was the last name again?
Lane, Brandon Lane, yeah.
So, Mr. Lane, you were charged with indecent exposure. You wanted to do the PC on indecent?
Yes, Your Honor.
You're charged with indecent exposure. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
May 26, 2024, officers were dispatched to a defendant touching his private area at the Metro-owned downtown transit center located on 1900 Main Street, Harris County, Texas. The officer was advised by Metro Dispatch that the complainant called and stated that the defendant was exposing himself to her. Complainant told officers that the defendant was a black male in a blue hoodie and boarded a Metro bus, and then ultimately pointed the bus that he had boarded. Matching the description, and complainant witness confirmed that that was the same person. Complainant stated that the defendant followed her from across the street, pulled out his penis, and started exposing it to her and looking at her. She further stated that the defendant began stroking his penis back and forth with his hands, looking at her without speaking, approximately 5 to 10 feet away. Complainant stated that she was unable to tell if he was erect, but she was able to clearly see his penis as he was stroking.
Your Honor, after speaking with my client, the officers approached 2 males. I have to wait on body cam to see what the other male looked like, but my client's saying that wasn't him. He just.
I mean, I don't know. I think that there's probable cause to go forward now. Mr. Lane. Mr. Lane, we will get the body cam to ensure and see if that is in fact you, because we don't know. All we know is that we have someone that has identified you. I will try to have them get the body. Do you have it now? What evidence do you have now?
This is a brand new case, Your Honor. This is the 26th, so I don't know. There's nothing in yet, so I literally just wrote this up before I came to court.
Okay, I will, Mr. Lane, I will try to have them get the information and the body cams as quick as possible so we can verify that it is you. I would say let's try hopefully a week. The problem is that I can't give you a PR bond because you continue to take off on us. I had your evading arrest at 7503 because we can't get you here. So, okay. Do you have any questions, sir? Hey, Hit the button, please.
Yes. Now she's got me. I was in New York. I don't know. I don't know if it was this All right. Same thing happened down there with me. That was.
Hey, Ms. Hayes, can we have him evaluated, please?
On his previous case, Your Honor, his first case in your court, he was already set for a mental health evaluation, but he absconded. He's homeless. So
The look that he was giving us, did you see me eyeing you to?
yes, I moved over. Yes.
Well, you see where I came from? You see-
Yeah.
He's pretty coherent when I'm speaking with him, but I've seen the episode coming about. So he's gonna be in custody. Hopefully we can schedule the evaluation. I'll speak to the CLO and go from there.
For sure.
Thank you.
Now then, let's take up Abel Estrada Jr. Mr. Estrada, you'll need to start your audio and your video.
And
Very hard. We are on the record in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Assistant County Attorney Paul E. Dean for the state. The defendant appears in person and pro se. The defendant, this first appearance back in October of 24, after being dismissed and refiled from municipal court, and some failures to appear. Then we had a bench trial February 14th, 2025, and the defendant was found guilty and ordered to pay $108 in court costs and the scheduled fine, with the court specifically ordering that if he appeals, an appeal bond set at the amount of costs and fines had to be paid before or at the time of the appeal. We had a peer review February 28th, 2025. Somehow he was attempting and made some efforts to file the appeal without a bond. He had gone through a couple of attorneys and then ended up representing himself.
also determine whether he's actually properly docketed it. He's told us that he has. He's told us that he's talked to people in the clerk's office and it's taken care of. But to date, there is not one piece of paperwork in my file that shows anything from the Court of Appeals, which we would have received electronic notification. Should have received notification of the docketing, should have received notification of the motion that he filed to waive the Court of Appeals to waive the appeal bond. I believe you referenced something of that nature at that time. I may be mistaken on that.
That's why I was walking through the history. That's what I'm finding too. When he was here May 9th, 2025, another payer peer review. Let's see. The defendant said he is outside the jurisdiction of this magistrate as he is strictly under the appeal court authority, that he had an appeal court case number, so I could not enforce the order for appeal bond or sentence, basically. So, have you paid? Does Mr. Estrada, did you pay the fine ordered of $158? The court file says you haven't. Looks like you had 108 court costs and a $50 fine for illegally display of license plate or not display.
Your Honor, I take that back. I think my office has finally found something.
Okay.
It just has not, the paperwork has not hit the file. Looks like transcript's been completed. Oh, well, table. Okay, we did receive, apologize, notice, court docketing notice, appellate court docketing notice. So I think actually at this point in time with that, and that, I don't know why it took so long to get to us, but with that, we can remove this case from this docket and we will take care of it at the Court of Appeals.
Let me see if I find everything. Okay, suspension.
I will have my office, I'm going to ask them to file that a record in this, at the trial court level. That way we have that in there. Judge, you don't see, you can't see that from your end?
Well, let me see. I'm seeing the transcripts.
And we did receive a letter. It's probably an emailed letter, but it is appellate court case number 128,986.
Okay.
So.
Okay, I did find it. Thank you.
Current jurisdiction at this point in time from the district.
Okay.
So.
All right. Well, we will just wait and see what the Court of Appeals thinks about your conviction, and I guess they're not going to enforce the order to pay the bond. So if the Court of Appeals decides that piece of paper was sufficient for requirements of tag violations, they'll let you go and it'll be over. But if they find that the conviction should be sustained, that that piece of cardboard that you bought from someone was not a legal tag, then they'll let us know and you'll still owe that money. Now, what I'm wondering, Mr. Dean, I think we might need to look at what appears to be some suspensions on his record for not payment, because if those suspensions for non-payment were filed by our county clerk or our district clerk after the appeal was docketed, those may need to be revisited. If they were done by the Department of Revenue in Topeka at any point in time, I can't overrule or override them. You have any thoughts on that?
Your Honor, I don't know who would have initiated that, because the case had been on continuance. I mean, the order's quite clear in this case. They would have received that notice of appeal. So I guess we just need to reach out to the clerk's office. Missy, if you could reach out to them on that, maybe we could find out an answer to that. I would agree there should be no suspensions as a base from this case, but the Court of Appeals has indicated on the letter that I just saw that they considered it properly, timely docketed. The appeal is timely filed, so there should be no suspensions as a result of this matter until we're back here or the Court of Appeals says that it's overturned.
But Mr. Estrada, you might be mindful and check your driver's license and see if the status is suspended, because it could cause you some grief if you're out there driving around with a suspended license, even though we may be able to clarify it eventually and correct, if it needs correct eventually, but it could cause some headache for both you and, for this court and the prosecutor having to come back and visit that, so.
And Mr. Estrada, why I've asked the judge's administrative assistant to check with the clerk's office because she's right down the hall from them. I think it would probably also behoove you to contact the Kansas Department of Motor Vehicles and question them about that status. You may find it easier to send them a fax because they're quite difficult to get to get a hold of anybody by phone. In any event, that's all I had, Rob.
Okay.
Well, I did get 3 different letters saying that I needed to pay, and I called them and I told them that I'm already in the appellate court, and there's no reason why I should be suspended. Is this gonna cause me any more problems? Is there something that I can call you back so that you can confirm to whoever I'm talking to?
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself. Perhaps send them a copy of the appellate court docketing statement, things of that nature. Maybe that'll help clear it up for
Okay.
All right, Your Honor. Can we take a short break before we get into our 10 o'clock? I don't have anything further.
All right. We're just gonna hold tight until the appeal is done. I'm not gonna set another case this time, Mr. Estrada. You're excused from today's hearings.
Blade. Good afternoon, and sir, you are Michael Anthony Blade, is that correct?
The beneficiary, not the other person, so that
I'm sorry?
the beneficiary and not the artificial person, sir.
Okay, I don't know what you mean by that. What is it? What's your name?
I'm the beneficiary, Michael, of the Blade
Right,
family.
I understand. You're the beneficiary of Michael Blade, but what is your name?
Your Honor, I'm the beneficiary of the estate, Michael Anthony Blade.
So is he deceased, or are you his guardian, or what?
For Michael Anthony Blade, the artificial person, I am the agent.
I don't understand you, sir. In any event, Miss Blade, do you recognize the person on the screen?
I do.
Is that your husband, Michael Blade?
Yes.
Okay, all right. The court tried to call you this morning, Miss Blade, but the phone number you provided on your summons was an invalid phone number. It was not a right phone number. We called you at 734-78. That's the number you had, and person said that's
I've never
not your
given
phone
that
number.
That's not my number, and I've never given that number.
No, that's the phone number we had for Kimberly Blade. Miss Kimberly Blade, we attempted to call you this morning, and your phone number that you referenced on your summons that you prepared is wrong. In any event, the court cannot enter the judgment as presented. It's got all kinds of red stamps on it, and it's got things crossed out. And the court, the reason the court was calling you, if you could come down this afternoon, we can get the two of you divorced if you want to get divorced. And we can give you another form, and I can explain to you, walk you through it. For example, someone said that there's a paragraph about the domicile of the child should not be moved from the state of Michigan without the consent of it's got to be the consent of the court. And Mr. Blade, you're correct. If she wants to move, she's got to seek the permission of the court. She must notify you in advance. So you'll be aware of all that. So I want to walk through these provisions with you. You've crossed some things out which are simply not acceptable under the law. So both of you live locally.
Excuse me, sir. Would you mind repeating that, sir?
Your request coming down here. There's all kinds of red stamps in here. It says non-assumptive. I don't know what that means, but it's all over the page. The court cannot sign this judgment. So what the court would like to do is sometime we can personally come down here and I can walk you through. We can prepare a clean judgment. For example, somebody's crossed out. For example, there's a paragraph about real estate, and someone says does not apply. Well, there are two choices. Either you own real estate and needs to be divided, or there's not real estate. So you need to address that. The court will not enter the judgment without these provisions being addressed. They're required in any judgment divorce. We must divide pension benefits. If you each keep your own, that's fine. If there are none, we need to note that. So this judgment is not acceptable. You can't get divorced today. So, Miss Blade, you live in Inkster, correct?
That's correct.
Is there a time you can both come in personally on Monday, and we can, if you want to get divorced, you've been separated since the last 4 years. Let's not drag us out any longer.
Yes, that's fine.
Okay, can you come down, Mr. Beneficiary? Can you come down also personally?
Your Honor, what we need is simply a divorce. That's all we need. Your jurisdiction.
That's correct. The court will not sign this judgment of divorce that's been presented. I don't know who made all these red stamps. There are things crossed out. I can walk this through with both of you, but you need both need to sign to prove the judgment.
Sir,
so I'm suggesting the easiest way for this to happen is both you come down here personally. If you come down on Monday, we can get you divorced on Monday.
Sir, anything I sign will have stamps.
Okay. Well, I don't know what the stamps mean.
Non-stamps, it means that I do not have liability for the state enterprise.
Sir, you're making no sense. If you want to put one stamp, but you got a dozen stamps all over this. Unacceptable. So what time do you want to come down on Monday?
That contract that I do not agree with, and those are the terms of the contract in which I.
All right. Then Miss Blade, you need to hire an attorney. Then you need to hire an attorney, Mr. Blade. I don't know. I don't know if he's got. I don't know if he has some incapacities, but he's not talking common sense. I don't know what you need in order to get divorced. So can you both come down on Monday or no?
Behavioral psychologist Leon Festinger's cognitive dissonance theory explains why people often protect a belief even when reality pushes back. The more someone invests in an identity built around sovereign citizen ideas, like the artificial person or contract theories, the harder it becomes to abandon them, even when doing so blocks the practical result they actually want.
Simple question.
I can.
I have work Monday. I've taken off work to handle this matter.
Well, can you drive down right now down to Monroe?
Yes, no, I can.
I thought you said you took off work today, Mr. Blade.
Yes, sir.
You live in Newport. You're probably, 10 minutes away?
I no longer live in Newport, sir.
All right. All right. So perhaps the court could take some brief testimony. There's been a breakdown. There's only that there's 3 minor children. I can take a brief testimony. I can preserve everything, but I can't get you divorced until we sign the written judgment. So can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Miss Blade? You need to unmute yourself. Cannot hear you, Miss Blade.
I do.
Okay. All right. Start with you, Miss Blade. Can you please state your name and current address for the record?
My name is
Miss Blade, Kimberly Blade. Can you please state your name and current address for the record? You need to unmute yourself.
300-8141.
Thank you. Miss Blade, is it true that you filed a complaint for divorce with this court on about May 4th, 2023?
Yes.
Is it further true that on the date you signed that complaint that you lived in the county of Monroe for 10 days in the state of Michigan, at least 6 months prior to filing?
Can you repeat that?
Is it true that on the date you filed that complaint, which was May 4th, that you lived in the county of Monroe for at least 10 days in the state of Michigan, at least 6 months?
I didn't stay in Monroe County.
I understand you didn't stay there. Did you live in Monroe County 10 days before filing this? For example, did you live in Monroe County the last week of April of this year?
No.
Well, you may need to refile in Wayne County then. You live in Wayne County. You need to file in the county in which you reside.
Yes.
I did. I went through this agency, a legal Zoom divorce, and they did it that way because Michael was in Monroe.
All right. Okay, we can establish jurisdiction with Michael.
No, not this. No.
We'll address that. Mrs. Blade, is it true that you married Michael Blade on May 2nd, 2016? You separated in September of 2020.
Yes.
Is it true there's been a breakdown of your marriage relationship?
Yes.
Have the object of matrimony been destroyed?
Yes.
Is there any chance of reconciliation?
No.
Is it true there are 3 children born of the marriage, namely Boy Blade, Kingston Blade, and Killian Blade?
Yes.
Were there any other children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Okay, sir, can you, Mr. Blade, did you live in the County of Monroe, State of Michigan in late April of 2023?
I lived in the domicile of the United States of America Republic, sir.
Okay, what do you have to, was it Monroe County, Michigan?
The domicile of the United States of America Republic.
All right. The court's not going to play games. The court's going to dismiss this complaint for lack of jurisdiction, Ms. Blade. Mr. Blade will not acknowledge he lived in Monroe County, State of Michigan. So I'm going to dismiss this complaint for lack of jurisdiction. You need to refile in Wayne County. And I'm sorry if Mr. Blade won't cooperate with you. He's not going to cooperate with the court. I'm not going to play games. The court will dismiss this complaint. Now we'll conclude the matter. You can all zoom out. We'll send you both a copy of the dismissal. And Mr. Blade, we have your address of 8 Newport. That's where we're going to send the order of dismissal. All right, you can both zoom out. Have a good rest of the day. You're still married.
All right. Good morning, Ms. Rivers. Are you able to hear us?
Yes, I am. Good morning.
Good morning. So let's first please have a quick conversation with Mr. Pritchett, and I'd like to have that on the record. So that's the case of 20 SC 176922. Mr. Pritchett went to trial a while ago, and there was a motion for new trial, timely filed. And Mr. Pritchett, good morning. Are you able to unmute there?
Yes.
Great. Good morning. I had you, and let me get you right there, added to this conversation this morning because we needed to confirm with you your plans for representation, whether for your motion for new trial, you were going to represent yourself, if you or your family would be hiring someone, or if Mr. Hewitt, who is on the call here, would need to be called upon to line up appointed appellate representation.
On my end, I am still currently confirming just private representation. Now, I did speak with the public defender office briefly a minute ago, as far as just letting them maybe at this point help with the process to the extent that is necessary and what is needed. But I know ultimately the ball is still really in as far as moving forward, it's still in the court's hand, because we at this point, I mean, I'm not aware of any transcript that has been produced regarding the trial, and I know that is needed to proceed forward with or without an attorney. I mean, of course, for the new trial. Is that not correct?
So certainly a transcript is necessary, and you, if you're representing yourself or your lawyer, is 100% entitled to it. And the ball doesn't really get rolling until there's a transcript. And so I guess in one respect, we can wait until the transcript's done and then reconnect with you and have you decide. It's just helpful for Mr. Hewitt's team if they know that they need to line someone up. There aren't a whole bunch of attorneys statewide who focus on appellate practice like this. So you don't need to commit right now. It sounds like maybe that's still a little bit in flux. I'm calling your case up right now just to make sure the transcript didn't sneak up on us.
It did not, Your Honor.
Okay. Mr. Armstrong's checked, and the last I've seen is there's an amended notice of appeal letter from you, Mr. Pritchett. There was one in April and another in May. So we are in this moment of pause. Ms. Rivers needs time to get the transcript done. But just typically what happens is we find out before then, all right, this is the lawyer for Mr. Pritchett. Here's who's representing the state. And we talk a little bit about scheduling. But that's more preparatory. You're right. Nothing can happen until that transcript's done, so that either you, if you're representing yourself, or a lawyer can pour over it to say, hey, here's where the judge made a mistake. Here's where whatever happened. So why don't you tell me right now which way you're leaning, and then we'll find out from Ms. Rivers what she forecasts for completing the transcript. I don't know where this falls in her list of cases that she's working on.
I like I said, just me confirming just the private counsel that I have and my family has been in contact with. Of course, nobody has entered any appearance on the case as of yet. But again, that is still being confirmed. What I will do, I think at this point, just thinking about the conversation that I had with the public defender office, I will fill out the necessary forms. I think for their procedure as far as retaining counsel, there is some type of forms or questionnaire that they needed me to do, just ultimately, if I was to lead in their direction, that needed to be complete to ultimately move forward. And I think that would have made their process easier if I was ultimately to end up in that route. So I know just, I guess, for them to be on proper standby and not just lingering, I guess I can fill those forms out for their offices. Ultimately, if that is the route I will take, it will be ready, at least to be taken. But at this point, nothing has been confirmed.
Okay, I think I follow all that.
Your Honor, may I mention something just because it's a possible snag and I want to make sure? I assume it's something that in this division of the court is not an issue. But because he represented himself at trial, I wanted to point out that applying for public defender assistance is good for establishing indigency, because that is what Georgia law has as the marker that establishes indigency is the public defender's office. And both the formal request for a transcript to the court reporter, but also how the transcript gets paid for is determined by indigency. And so if he files the indigency form and that goes into the record, that directs the court reporter to file it regardless of whether they're paid for it by other means.
Got it. Okay. That's a helpful piece of advice. So Mr. Pritchett, that's yet another reason for you to fill out that paperwork that would document, assuming it's accurate, that you qualify for appointed representation. The transcript will be completed. That's not what Mr. Armstrong was saying, but the question of how it gets paid for, if it has to be paid for, is driven in part by your financial means. If it turns out that you've got $100,000 on your books at Wheeler, then you're either hiring a lawyer who would be paying for that transcript, or you're representing yourself and you're paying for the transcript. But we aren't in that situation right now. Let me ask Ms. Rivers, who I know is writing things down, if she could give us a rough forecast of when she thinks the transcript in this case will be done.
Mr. Pritchett's case is actually next up to transcription after this.
I'm sorry, I couldn't quite hear that.
Can you hear me?
Yes.
Yes, Mr. Pritchett's case is next up to be transcribed after Sanders and Pittman, and I forecast that to be around August to be complete with both cases.
Okay, then why don't we do this, and then I want to hear from you, Mr. Hewitt, because we'll limit the number of times you need to plug in like this. It seems like if we got Mr. Pritchett and you, Mr. Hewitt, back on, and Mr. Armstrong or one of his colleagues in August, and Ms. Rivers and I work together, so I'll be checking in with her. But if it looks like that transcript is wrapping up, then we ought to get everyone together again, and that will truly be the crossroads for Mr. Pritchett, because he'll have more time to work through with his family whether they're retaining someone, or he will have completed the paperwork to get GPDC in the mix, and then he can let me know which of those three options, assuming he qualifies for GPDC representation, which of the routes he's going to pursue, and that will be an actionable clock will be ticking by then. There isn't anything we could do right now because there's no transcript, but by August there ought to be one. And so it'll be a little more pressing for Mr. Pritchett to say, hey, here's what I want to do. Mr. Hewitt, anything you want to add, or does that work for you?
That works for me. I just add just so Mr. Pritchett understands what I'm doing here. I'm not his lawyer. I'm the statewide supervisor of the appellate division. And so I'm just sort of hovering over this case. You know, if we do need to appoint somebody, then I'll get that. I'll make that happen. And but if he wants to go pro se, that's fine too. Or if he doesn't qualify, that's fine too. But
right.
I'm just sort of here to try to facilitate things. And I sometimes when I do these, the defendant thinks I'm their lawyer, but I'm not. Okay.
Nope. I appreciate you flagging that. I think Mr. Pritchett understood that you're in that supervisory capacity. And I appreciate him pointing out, hey, without a transcript, it's sort of moot right now. So I think that's where we are. Mr. Pritchett, anything you want to add? I had muted you because there was some background noise. You got to unmute.
Okay, King. There is one concern I do want to address, and that is regarding your response to the motion and the rest of the judgment that I filed. And honestly, Mr. McBurney, it does seem odd because the response to it was just pointing out my untimeliness for the motion that was filed, rather than discussing the issue at hand. And honestly, the timeliness was impossible, and it don't seem how it was constitutional. It does seem like it violated multiple of my rights because the judgment was entered May 2nd. The last date that I had to file that motion was May 6th. That was 4 days after you attempted to sentence me to football numbers. So it just, I don't see how it was just constitutional as far as you ruling in the direction that you did on the motion, honestly, sir. And again, like I said, the main issue wasn't at hand. You're trying to hold me to a standard as far as the timeliness and filing that I don't believe that even the court are holding the district attorney to, because the main issue at hand was, okay, well, is there, a record reflecting the return of the indictment in court? Heil stood up in a hearing. There is a record of this. I have the exact timestamp on one of the videos that you have on your YouTube channel of Mr. Heil stating specifically that there is no minutes. Minutes do not exist of the return of the indictment being returned in open court. That's not even how the process worked. And it really was a clear statement that was against the laws and procedures regarding that process. And so again, the issue at hand wasn't addressed, and I feel like I was being held to a standard as far as filing that was just I couldn't do it, honestly, sir. And,
okay.
and so I can there be some type of it needs to be some type of reconsideration that I'm just kind of asking for as far as that motion is concerning.
So two things. One, that may be something that you or your appellate lawyer chooses to bring up when when an amended motion for new trial is filed. But number two, I note in the record, you have already filed a notice of appeal of my order. So that's out of my hands. You have appealed it. You'll pursue that appeal, and we'll see where that goes. But I don't have jurisdiction over that order now because you have challenged it, and you will navigate the Court of Appeals channels consistent with that notice of appeal that you filed. So you, as I said, may end up weaving it into the amended motion for new trial. Can't do that till we get our transcript in August. But before then, you'll be able to continue to work on that appeal that you filed. Anything else, Mr. Pritchett, before we get Mr. Ponder into your seat?
No, not at this point. Kind of call me over there, but I think that's on my end. I think that is it.
Okay, well, we will get you back onto Zoom in August at some point to see how we're doing with the transcript and to get a more final answer from you about representation. Mr. Hewitt, appreciate you joining us. You're welcome to stay for the Ponder one, but he's got a lawyer. His lawyer's sitting here in court, and we're going to pivot to that now.
I think I have plenty to do today. I appreciate the invitation, and like I say, if y'all have any problems, you can have Ms. Hansberry contact me on any of these appellate cases. I'm glad to straighten things out. That's what I do all day. Okay?
It is, and we appreciate your help. Thank you, sir.
Can I be excused, Your Honor?
Yes.
Okay, thank you. Mr. Pritchett, do you have something you want to say to me, or?
Mr. McBurney, can you just give me just a brief summary? Okay, after me filing the amended to your motion, what could I expect next as far as that process?
So you have appealed the order that I entered that dismissed your motion in arrest of judgment. So you see what else is in the docket. You had your notice of appeal. The clerk's office has sent to you some information. It's a checklist that you're supposed to complete. They most recently sent a letter in May to you, and you'll work through that. That's what you need to do to ensure that the record that's relevant to the motion in arrest of judgment gets to the Court of Appeals.
And that's the problem. How do I get that how do I get the record? I mean, how do I get that record?
So the clerk's office transmits the record. You don't have to go around doing anything, but they sent you a checklist, and they highlighted a couple things in that checklist that they're saying you did not include. And so you'll need to interact with them, not with me, about that. So you should be looking for that letter if you didn't receive it, although it was sent by certified mail, and it looks like, so it should be there by now.
All right, appreciate it.
You bet. All right, if you could get Mr. Ponder, please.
Thank you, Your Honor.
Thank you, Mr. Hewitt.
These hearings involve different courts, different legal issues, and different people, but they all reveal the same lesson about how the legal system works. Courts respond to procedure before they respond to personal belief. Whether someone is challenging a traffic conviction, trying to complete a divorce, or preparing an appeal after a criminal trial, every outcome depends on following established legal rules. The first case demonstrates that procedure can sometimes protect a defendant as much as it protects the state. Once the appeal was properly recognized, the trial court adjusted its position because jurisdiction had shifted. That wasn't a victory for any legal theory about sovereignty. It was the result of the appellate process operating exactly as designed. The second case shows the opposite problem. Sovereign citizen concepts such as the beneficiary, the artificial person, and rejecting legal identity may feel internally consistent to the person using them, but those arguments never address the procedural questions the court needed answered. As a result, the underlying family dispute remained unresolved, leaving everyone involved without the outcome they were seeking. The third case highlights another important difference. After a conviction, the focus is no longer on debating jurisdiction or repeating earlier arguments. Appeals depend on transcripts, deadlines, preservation of legal issues, and identifying specific legal errors. Those procedural steps create the framework that appellate courts review. Across all three hearings, the common thread is accountability through process. Courts may disagree, make corrections, or even reverse earlier decisions, but those changes happen through documented procedures rather than personal declarations. Every filing, deadline, transcript, and jurisdictional rule exists because appellate review depends on an accurate legal record. In the end, these cases are less about winning an argument in the courtroom and more about understanding which arguments the law is actually designed to evaluate.